results. So the topic today is, have you updated your handbook recently? We all know that
Nope.
Ames Wayfinder.
That is not a
Yep.
question we have today. That was in the it was in the pool of possible questions. The two questions that we do have, if you're wanting to look at it, is do you have a separate procedures manual for supervisors that gives guidance on how employee
Hey,
handbook
hey,
policies?
hey, Nick, I know that's not the poll. I'm just asking the question, have you updated your employment
Oh, I have
handbook
not.
recently?
I have not. Oh, you're
All
asking the
right.
audience. I'm sorry. I thought this show was all
Yes,
about me.
exactly. So we've talked about the fact that we know that AIM is holding its Wayfinder conference down in Florida pretty soon, and there's excitement of the technology AIM has injected into its Florida operations. They have resources available to help employees with employee handbooks, and one of those resources is, in fact, Chris Cruz. Chris, welcome to the program this morning, and thanks for joining us.
Thank you very much, Burt. I appreciate the introduction and your update on what's happening in the world of employment law court cases. So today's program is going to focus on updating handbooks. And I'm going to address this first poll question because Burt and I had a conversation prior to the program starting about, do we have a separate procedures manual that gives guidance on how employee handbook policies are to be administered? And the reason I asked that question, and we're asking that question, is I've seen far too many handbooks that get into minutia and detail that don't need to be in there. They're addressing specific guidelines as to, for example, Burt, as you pointed out, how we're going to investigate a claim of discrimination. And that detail doesn't need to be in a handbook. It's going to be discoverable. Even your procedures manuals can be discoverable. But Burt, why don't you share with me what you spoke to me about prior to this starting?
Sure. So, Chris, and I appreciate that. So you and I, what we chatted about is that, let's say that an employer gets a complaint of discrimination or harassment. And if that employee handbook contains all of the minutia and the detail on how an employer is going to commence an investigation, what's going to happen is that eventually, if you end up in court or you end up in depositions, a plaintiff's attorney is going to pick apart every aspect of that procedure that you as the employer did not follow. It is simply enough for you as the employer to have in your harassment and discrimination policy a statement that says, when a complaint of harassment or discrimination is made, or frankly any other complaint, the employer will investigate. And that's simply all you need. You don't need to start getting into, this is how the employer is going to investigate. We're first going to sit down and interview the person who's been affected by the harassment and discrimination. And then once we do that, we're going to sit down and we're going to go over video evidence and computer evidence. And then we're going to interview everybody who the person says witnessed this. And then not only that, we're going to interview everybody in the whole company. And, you know, you go on, the procedure could be endless. And every complaint of harassment and discrimination is its own animal and needs to be treated as such. You cannot lock yourself as the employer into a rigid mechanism of what's going to happen when a complaint is actually made. Chris, what are your thoughts on that?
Absolutely. I absolutely agree. In terms of handbooks, procedures, we want to give the employer as much flexibility as possible in administering and making decisions based on their policies. So we don't want to lock ourselves in to something that we down the road can't follow or fulfill.
And
yeah,
actually,
perfect.
yeah, I
Go
was
ahead.
going to ask a question here, Chris, since really coming off of that. So you can't cover everything possible, right? That could happen. So, you know, one of the things we're curious about is, can you address an issue with an employee if it's not covered in the handbook? Does that leave you out in the blue?
Nope, absolutely you can address those issues, because I am never surprised by the creativity employees can use to push the boundaries of our standards of conduct and behavior and professionalism. So, for example, in all the handbooks I've reviewed, I have never once seen a statement that says, "Thou shalt not spread feces on the bathroom wall or floor." Yet at least once or twice a year, I get a question. We have someone who's spreading feces on our bathroom wall or floor. Okay, we don't have handbooks that address those specific issues. We don't have handbooks that have policies that say you and your coworker can't go into your car in the company parking lot at lunchtime and have sex. Yet here we are dealing with those issues.
I don't know. That sounds Florida specific to me.
I don't know, Burt. I'm guessing you probably fielded some of those questions too.
Yeah. Well, Chris, I mean, that's why in every employee handbook, I do recommend that employers have an anti-species spreading policy in there specific. Yes. No, I'm kidding, of course, but I think you're right that handbooks need to be broad enough and have certain sections that capture those types of misconduct in the workplace.
Absolutely. That's why we say in our rules of conduct, includes but is not limited to. Again, we want to give the company flexibility. Language. Yeah. Right. So
exactly. So Chris, real quickly, what should employers be concerned about with respect to their handbooks right now? What's going on right now that employers need to be paying attention to?
Well, right now we have had a lot of legal changes in both federal and state laws throughout the country. So, for example, earlier this year we had the Pump Act that passed. And it's surprising how many employers don't even have in their handbooks a policy regarding lactation breaks. We need to address that. We have the Pregnant Employee Workplace Fairness Act that passed earlier and went into effect back in June. So just as we tell our employees that if you need an accommodation under ADA, come discuss it with HR. If you need a religious accommodation, come discuss it with HR. I think we probably need language in our policy to talk about if you're pregnant and need an accommodation, come talk to HR. And we also have a National Labor Relations Act board that if we've been in HR for a period of time, they have issued recent board rulings from the National Labor Relations Board similar to those that were issued probably around 2012. And they're strictly interpreting our handbook policies and are wanting to make sure that our particular policies, especially around confidentiality, personal conduct, conflicts of interest, harassment, don't chill an employee's rights under the National Labor Relations Act. So under President Obama's NLRB, we saw similar board rulings. And now under President Biden's board, we again are seeing similar rulings that may affect some of the policies that we have. Burt, do you have any comments on that?
Yeah, I think those employers who revised their employee handbooks back in during the Obama administration and then scrapped those employee handbooks during the Trump administration are wise to consider dusting off those Obama era employee handbooks and using that as sort of the starting point and then updating it with these new laws that you mentioned, Chris. So, so that's kind of my thought on that. Chris, what are some of the traps that you see out there right now? Some of the don'ts that employers should be wary of, in addition to making sure their handbook is not full of procedure.
Okay, well, one of the first issues, and it relates to our poll, is if we're operating in multiple states or multiple municipalities, we want to make sure that our policies address any specific laws in those areas. So I'm happy to see that in our poll results, our polls are showing that for those employers that operate in multiple states, multiple municipalities, they have specific policies that address those differing laws, those differing ordinances or state laws. The other thing so I'm happy to see that. In terms of a due and what we want to see included, we want to have a statement in our handbook that a handbook is not a contract. We want to retain the right to change policies, wages, benefits, and working conditions. And I believe, Burt, you were explaining to me that when you have draft acknowledgments for employee handbooks, you like to see 3 or 4 separate acknowledgments. Can you tell me about that?
Yeah, so most employee handbooks that I run into have a single acknowledgement, and that's the general handbook acknowledgement that I acknowledge I have received this employee handbook and that it's my obligation to read and understand the contents of the employee handbook. And if I have questions about the handbook, I will address those. And oh, by the way, this handbook is not an employment contract. You are an at-will employer. And that's sort of the general employee handbook acknowledgement. And that's important because it gets the person to acknowledge several things. Number one, that it is their burden to read the employee handbook and understand it. And number two, it gets that potential contract issue out of the way, that the employee handbook is not a contract of employment. It is a handbook, and it's meant to inform employees of the policies of the company. It's not meant to create an employment contract or change the at-will nature of the employment arrangement. So that handbook acknowledgement is obviously very important. But there are two or three other acknowledgments that I recommend being included in a handbook separately from the general acknowledgement. And that is because there are 2-3 areas where employers are most likely to face litigation. And those areas are, of course, in the area of harassment and discrimination, what I was talking about initially on the program today. And so I like to have a separate acknowledgement of the employer's harassment and discrimination policy. And the reason for that is that policy places several burdens on the employee, namely the burden for the employee to make a complaint, or if they see harassment and discrimination taking place, they have to bring it to the attention of the employer. And so I want the employee's acknowledgement on that document so that if I'm sitting across from them in a deposition someday or in trial, and they say, well, my employer threw this 40-page handbook at me when I signed up for employment and told me I needed to read it, but I didn't really read everything closely. So I didn't really read this harassment discrimination policy. It is much easier for me then to take out that separately acknowledged harassment and discrimination policy and then ask the employee, now, isn't it true that during your orientation, your employer actually presented you with this separate policy and you read it and then you signed it, correct? And it makes it much harder for the plaintiff to avoid saying that they didn't know what was in there. The second area where you're highly likely to end up in litigation with employees is related to confidentiality as it relates to the employer's confidential, proprietary, and potentially trade secret information. And so every employee who works for an organization should have an obligation to maintain the confidentiality of their employer's confidential, proprietary, and trade secret information. And then third, the last acknowledgement that I would want in there, if you are an FMLA covered employer, I would want a separate acknowledgement of the employer's FMLA policy. And again, the reason is exactly the same as my reasoning for wanting that separate acknowledgement on the harassment discrimination policy. And that is, I don't want an employee coming back to me down the road and claiming ignorance about what was in a specific policy. And again, since those are the policies you're most likely to end up in litigation over, I do recommend, even though it is an administrative burden, I do recommend having those separate policy acknowledgments. Christine, I'm curious about your thoughts on that.
I agree. I think it makes perfect sense to me. And I think for all of us, for all employers, we should be, first of all, during orientation or whenever we roll out a new handbook, I think there needs to be a briefing with our employees, specifically directing them to those, that non-discrimination, non-harassment policy, our FMLA policy, our confidentiality rules, all of those. I think we need to make that part of our rollout of our handbooks. I think we need to make it part of our orientation when people are onboarded. So I think that makes perfect sense. And certainly we want, as employers, we want to make it as easy as possible for our employment law attorneys to defend us when, not if, a lawsuit occurs.
Yeah, that's exactly right. Not if, but when. Well, Chris, I can't thank you enough for participating today and providing us your valuable insights on employee handbooks. AIM does employee handbooks. You could see a little promo on the screen about what AIM offers to its members regarding employee handbooks, and know that most the employment law firms also do employee handbooks. Not that we're trying to compete with AIM, but we do have a little bit of a different focus from a legal review standpoint. And so AIM offers some really advantageous pricing to get an employee handbook jump started. And even after AIM does a handbook, you still may want to have it submitted to legal counsel for review in any particular jurisdiction in which you're operating.
Thank you once again for tuning in to This Week at Work. If you enjoy the show, please share it with your colleagues. Forward our invites. Share the link, aimea.org/thisweekatwork, or follow or subscribe wherever you get your news and entertainment, like LinkedIn, YouTube, Spotify, Apple Podcasts. We're everywhere you are. And you can be part of the show. Send your questions and comments anytime to info@thisweek.work. We'll see you next week, 7:30 a.m. Central Time, when we discuss what's happening this week at work.